Thank you so much for being here, everyone here who is here in person and also joining us online. My name is Barb Van Foy, and I am the Policy Planning and Engagement Coordinator in the City of Colorado Springs Housing and Community Vitality Department. How's that for a long title?
That's a long title.
Both the city and our department name. We are really pleased and always grateful to be able to work with the community partners that we work with, really to make these happen, especially to Colorado Legal Services. And so just to give you a quick overview, so the reason that the City of Colorado Springs Housing Department is involved in this is that we want to keep people housed in our community. And we also want to help educate residents, both renters and landlords, as to what the laws and responsibilities and rights are, to help reduce conflict between landlords and renters and to keep people housed. So just a reminder, this presentation today will provide a lot of information about the laws and the requirements. There have been a lot of new laws in the last couple of years, but it's not a legal clinic in the sense that if you have a particular case or a situation, we will not in this event be able to specifically address your situation, but all of the partners that we work with, or many of them you'll hear from or about, can help provide those services depending on what you need and what you're looking for. So we'll go through that. I first want to thank Silver Key Senior Services for helping to host this event and to have us here today. And I'm going to tell you briefly about some of the organizations and what they provide. For those of you who are online, we'll be putting all the links to these organizations in the chat, so you'll be able to click on those. For those who are here in person, if you registered or if you sign in to the sign-in sheet and give us your email address, we will share the recording video of this, and we'll send out the links and we'll send out the presentation, the slides. And those will also have the links for all of these resources. So Clinton will talk more about Colorado Legal Services when he gets up here, but they provide income qualified legal representation. So for those who, if you think you have a case and you want to request legal services and representation, you can apply on their website. As I do this, I want to share with you some of the websites. I'm going to have to stop sharing and start sharing. So this is Colorado Legal Services website, where you can find more information and potentially apply. And then thank you so much, Deb Hamilton, who is the Pikes Peak Library District's, those of you in person, that's her in the corner, is the law librarian. And she and the law library at the Pikes Peak Library District has a huge amount of information. She can help point you to specific legal resources and also help connect you with any of these resources here. And oops, I thought I had their website up. It's over. Oh, shoot. Apologies, everyone. There it is. So once you get to the library's website, you want to search for and find the Law and Legal Resources section. And again, we'll send you the link. Okay, so next is the Justice Center. So the Justice Center provides pro bono resources. They have clinics and they have a call a lawyer program. They have a tenant toolkit on their website that you can find videos about how to manage certain things. You can find out when and where their clinics are. There are places you can go in person and potentially meet with a lawyer right there to talk about your particular issue. And they also do their call a lawyer. We have with us Patrick Noonan, who is with Colorado Housing Connects and the Brothers Redevelopment. And so I will let Patrick unmute himself and tell you a little bit quickly about what they do.
Thank you so much, Barb. My name is Pat Noonan, Program Director for Colorado Housing Connects. I can't be there in person today, but I do have some colleagues in the room, and they believe they brought some materials to share if you want to learn more. The quick overview of what we do is answer all sorts of housing questions. If you're looking for affordable housing, you're looking for help with your rent, maybe you're sick and tired of renting and you want to know more about home ownership, we have a class coming up on October 12th. We've got all sorts of housing information and resources, and you can reach us at coloradohousingconnects.org or give us a call. Thank you so much.
Thank you so much, Patrick. And those of you who are here in person, we really appreciate your services. One of the resources we most frequently refer people to. So, okay, and then we have Silver Key. We are here at Silver Key Senior Services. They provide resource navigation, some housing navigation. They are building some affordable housing for seniors. Again, we will send you their website, and we do have some flyers from Silver Key. And of course, here in this space, you can also find brochures with some of their services for those of you who are here. And at the City of Colorado Springs, in the Housing and Community Vitality Department, we maintain a website called Housing Help and Resources. And this is where we include links to all of the resources that we are familiar with, that we know exist, to help folks who are struggling with housing and a variety of housing issues. So please do look at that for several resources. And then we have a website about this renter rights program and the guides that we do. So actually, I'm going to click on this other page. So here we include information about upcoming events around renter rights. And we also host the videos of all of the past presentations that we've done. Sometimes we've done ones that are specific to lease basics, or we did one, I think, on habitability, on safety and cleanliness issues. Do keep in mind, this will be said a few times today, there have been new laws passed in the last couple of years at the state legislature that have really changed things. So one of our resources that we provide, you can see on this website, is the Renter Rights Packet. It's in English and in Spanish. We have some copies of it here in person. However, it was updated last year. And that means that the new laws are not in it. And so once we publish the slides for this presentation, we will have a link to those in the Renter Rights Packet, so that if you get the updated Renter Rights Packet, you'll know, because if you click on it, oh, that's the wrong link. It will say on the front the date that it was updated. And so make sure to pay attention to that because of those new laws, which thankfully Clinton is going to tell us about today. And in fact, speaking of, I think it's time for the main event. One thing, a little housekeeping for those of you who are in person here. If you need to take a bathroom break, you go straight out the door and you can turn immediately right and then left. Go straight and then turn right. And those online joining us, please do mute yourself. Mute everyone.
Yeah, you're unmuted.
Excellent. Okay. Well, in that case, I am very pleased and so grateful to introduce Clinton Albert, who is an attorney with Colorado Legal Services, and he has been working in the realm of landlord-tenant law for quite some time now. And he's got a lot of information to share. So please join me in welcoming Clinton Albert.
Share screen here.
Here it is.
All right. Good afternoon, everybody. My name is Clinton Albert. I'm the Assistant Supervising Attorney for the Housing Unit here at the Colorado Springs office for Colorado Legal Services. This afternoon, we're going to be covering quite a lot of material. Right, so you're going to likely have some questions that come up throughout this time. Write them down. We'll take questions at the end, okay? Because we have quite a substantial amount of information. For folks that do have the housing packet in front of them, I will be the first to admit that I have not been able to update that yet. So from the slides that you will receive from this presentation, if you see something, the slides are going to overrule anything in the packet because the slides are going to be discussing a lot of the new changes that have gone into effect this year. So if anybody attended the presentation in June, we'll be going over those changes again. There were quite a few of them and we had a number of questions. So I wanted to kind of revisit these new changes because they are affecting a lot of the tenancy and a lot of obligations for both landlord and tenant. Is that better? All right, I'll wait until I'm told I screwed up again. Sorry about that, folks online. As I was saying, if you are looking to apply for an issue, we have the information on the screen there to apply, have the phone number, as well as the website, and also our in-person address here in the spring.
This. That is showing your.
I might have accidentally muted myself again. I'll try to be mindful. Please keep yelling at me online, folks, if I accidentally mute myself.
Okay. Good now, it says.
All right. So at the end of a tenancy now, there must be a reason that your tenancy is ending. And it can't just be any reason at all. So it's a limited. So what used to be referred to as a notice to quit is now a notice to terminate a tenancy. What does this apply to? So these new rules don't apply to all tenancies and all rentals. They don't apply to short-term rentals like Airbnbs. They don't apply to employer-provided housing. Mobile home tenants with equity in the home, whether that's an owner or an option to purchase or a lease to own agreement. Tenancies where it's been less than 12 months. So these no-cost protections kick in after 12 months of occupancy. Also, tenant not known to the landlord to be a residential tenant. This doesn't necessarily mean a squatter. It could also be somebody using a commercial lease for the purposes of a residential lease. That would be somewhat of a more novel issue to come up. Also, a property where the owner or a master tenant lives in the premises and the premises is less than 4 dwelling units, whether that's a single family residence with kind of rooms for rent, duplex, triplex. Also, these These rules do not apply to a property where the owner lives in a property adjacent to the residential premises and it's less than 4 dwelling units. So we talked about where this applies. So what does this change mean? Well, like I had indicated a few slides ago, before this would have been referred to as a notice to quit. No reason would have been required. Any reason or no reason at all within the bounds of the law and also fair housing. So different notice periods were going to be provided based upon the length of the tenancy period under a notice to quit, which still applies for folks that this law doesn't apply to. So if we're thinking a tenancy of less than 12 months, that's where these rules would still apply. However, with the notice to terminate tenancy, there is a reason required to terminate the tenancy, and it must be stated in the notice. The notice is also a 90-day written notice. So what are the reasons? We've now kind of established that we're looking at a 90-day period to end a tenancy, and there must be a reason. Well, what can those reasons be? Pre-existing laws regarding evictions, such as non-payment of rent, substantial violation, repeated violation, the reasons outlined in that statute where it defines unlawful detention, and also the limited justifications for a notice to terminate tenancy. And that's where we're going to transition to now, is the recognized reasons to terminate a tenancy. We've got the demolition or conversion of a residential premises. We're going to talk more about these, so don't feel you have to write these all down. All right, landlord or family member assumes occupancy. We're withdrawing the property from the rental market. We're going to put it up for sale. If a tenant refuses to sign a new lease with reasonable terms, there's a history of non-payment of rent. All right, so let's start with demolition or conversion of a residential premises here. This happens when an owner plans to demolish the premises, convert it to non-residential use. That's why I used that little picture of an insurance building on a home, or convert it to a short-term rental like an Airbnb or VRBO. But it's not just that you think you're going to do this as a landlord. You can only terminate a tenancy under this theory, under this reason, if you provide the 90-day written notice. That notice must include a description and timeline of the demolition or the conversion of the premises, and a material demonstration of the proposed date when the project will commence. Not just I'm going to do repairs on the house, I'm turning it into an Airbnb, but that demonstration can include building permits, applications for permits, licenses to operate a short-term rental if that's applicable in your municipality. So it's got to be more than this is what I want to do. It's I'm doing this, and you have to state those reasons in the notice. So during that 90-day period, the tenancy still continues on the same terms and conditions. The next reason that we're going to get into here is when we're doing substantial repairs or renovations on a property. So a tenancy can be terminated for substantial repairs and renovations if there's a properly served 90-day notice with a date to vacate the premises, an expected completion date, and a general description of the repairs or renovations. Now that completion date is very key, and also a description of the renovations. Also, the project must then proceed without unreasonable delay to begin repairs or renovations after that 90-day notice ends. And this is why that date of completion matters, among other things such as putting somebody on notice. If the work is expected to last less than 180 days, then the landlord must provide the tenant with a notice including the expected completion date. And then that operates somewhat as a right of first refusal for that tenant to then move back into the premises after the work has been completed. But they've got to respond within 10 days saying that they would like to return to the property and that the landlord shall offer them the right of first refusal on a new rental agreement with reasonable terms. And then if the tenant does accept that agreement, they will then have 30 days to move into the property unless the parties agree upon an extended timeline because of extended waiting circumstances. Now, another thing to keep in mind when we're talking about repairs and renovations, you cannot terminate a tenancy for substantial repairs if you need to do the repairs to fix your breach of the warranty of habitability. Right? If you're doing repairs to make the home habitable, that is not a reason to terminate the tenancy. Also not can also not terminate a tenancy for repairs if the repairs are initiated in retaliation. The third reason here that we're getting onto is where a family member or the landlord themselves wants to move into the property. So when the landlord or the landlord's family member plans to move in, they can do so upon properly serving a 90-day notice to the tenant. There's no substantially equivalent unit available for the landlord and or the family member in the same building. And the landlord does not list the property for rent for at least 90 days after the date the tenant is required to vacate. There's some exceptions here. If the landlord is active duty military or a spouse of active duty military, then it only has to be a 45-day written notice for that landlord or the family member to be able to move in. If the individual, if the landlord or the family member has a disability, then you may extend the 90-day move-in period for any necessary accommodations to be made to the residents. But we're not going to, so the landlord's not going to move in. They're actually going to take the property off the rental market and put it up for sale. So what does this process look like? Well, again, it's going to be that properly serving a 90-day notice onto the tenant and does not list the premises for rental of any kind, short-term or long-term, for at least 90 days after the tenant's move-out date. And this does not allow a landlord to terminate a rental agreement early without cause. Okay. So if you're in the middle of a 12-month lease, this is not a way to circumvent a lease period. What happens if we're getting to the end of a tenancy period, a new lease is presented, and we refuse to sign it? That is a reason that our landlords can terminate a tenancy. Now, under this, if a landlord wants to terminate a tenancy because the tenant refuses to sign a new rental agreement, it's got to provide 90 days written notice after the refusal to sign the new rental agreement. Not just because of it, but there has to be an explicit refusal to sign the new rental agreement with written terms. And then after that refusal is when 90 days notice can be provided. There's also history of non-payment of rent as a reason to terminate tenancy. Now, there are rules and there are issues on this. So if a tenant pays rent late more than 2 times during the rental agreement term, the landlord may terminate the tenancy at the end of the agreement if the rent payments are late and the landlord has properly served a 90-day written notice. Where the details matter here is what is late. All right, so a rent payment is late if it is more than 10 calendar days after the day it is due and the landlord properly serves a valid notice or demand upon the tenant, not just that the rent's late, but there's a valid demand and there's valid service, and the tenant does not cure the non-payment during the cure period. So again, when we're talking about that notice to terminate tenancy and the reasons, if you're going to say that, if you're a landlord and you're going to say, well, I'm terminating it because the rent payments are late, you're going to have to detail which rent payments are late. You're going to have to detail the prior demands, because otherwise you're not satisfying the requirements for a non-payment of rent termination of a tenancy. And as a tenant, if you receive that notice and you don't have that information, it's very hard for you to say, no, I actually don't have a history of non-payment of rent. You're not placed on notice as to the actual reasons why they're terminating the tenancy under this theory. This is what one may look like. This is what a written notice to terminate the tenancy may look like. This is just a state form. It's 99B or JDF 99B. There's not a requirement for a landlord to use this form. They could write it on a Post-it note. I would generally say that's a bad practice, but so long as it includes all of the required information, it does not have to be on the state form. The state form can just make things a little bit easier to use. So it must include a statement of the legal basis and the factual basis for the no-fault notice to terminate tenancy. So that's why, kind of jumping back to the non-payment example, it's not just non-payment, but you have to have the facts to back it up as well. It also must include a mediation advisement, indicating that folks that receive certain types of assistance may be eligible for mediation at no cost to them prior to the filing of an eviction case. But again, similar to a factual basis, it must include a specific description of the alleged no-fault grounds. So not just tenant was late on rent twice during the rental agreement, but late in January, properly served a notice, cure payment wasn't tendered within 10 days, late in April, properly served a notice. You have to have that specific description. And also, the notice must be written in a language that the landlord knows or has reason to know is the primary language of the tenant. So if these new processes, if these new notice requirements are not followed, are there consequences? Yes. So if a landlord proceeds with an eviction for a reason not recognized by the new law, by these reasons, and the tenant loses possession without a court order, moves out on a written notice outside of the acceptable reasons, or, as a possible example, one of those theories where you can't list the property for rent within 90 days. Well, let's say the property goes on the market 10 days after you move out, when you were told the property is going to be sold or a family member is going to be moved in. Well, you were just dispossessed of your property without any kind of due process. So the tenant may pursue a claim against the landlord for an unlawful eviction if the new notice requirements are not followed. Unlawful evictions can have damages of $5,000 or 3 times the monthly rent, whichever is greater. So it can be a very steep proposition if the new laws are not followed. Now, landlords and tenants are free to get creative in their contracts. When they're signing a lease agreement, when they're writing up the terms. Well, in that creativity, can we add other reasons? Can we say, hey, we know what the law says, but we're going to add these 2 other reasons? No. A lease cannot waive. They cannot modify any part of these reasons, and any attempt to do so is not going to be worth the paper it's written on. It's going to be void. It's not going to be enforceable. So there are consequences, but is it a defense? If you're facing an eviction, is it a defense that the processes weren't followed? Yes. It's a defense that the new procedures were not followed. And if a landlord cannot show that they complied, then the court must dismiss the eviction case. We're not going to get a whole lot into retaliation tonight. There are laws that prohibit it, but landlords shall not increase rent in a discriminatory, retaliatory, or unconscionable manner to get around the no-fault eviction laws. That would likely come into play on the tenant refuses to sign a new lease agreement with reasonable terms, then probably going to be fighting over what is reasonable. So there were changes. So if you hear the phrase unlawful detention, that's eviction. So when an eviction case is filed, it's not titled eviction. It's titled forcible entry and detainer, because the law defines when somebody's not allowed to hold the property, hold the premises. They define that as unlawful detention. And there were some changes this year as to what an unlawful detention means. It's what on a legal level, this is what must be proven at an eviction trial. Lease violations other than non-payment and substantial violations, they now must be material violations. So a material covenant or a material condition of the lease agreement. Material is not defined by the law. That was going to be your next question. Going to likely have to wait for cases really to matriculate through the court system so we get better guidance as to what may be a material condition or covenant of the agreement. One new type of theory which could place the tenancy at risk is, for lack of a better term, quiet enjoyment. And that's where the tenant has disturbed others or caused a nuisance. The disturbance or the nuisance then interfered with the quiet enjoyment of the landlord, must live on the property, not if they're 3 states away. Others who reside in an immediately adjacent property, or other tenants, occupants of the same property. Or the tenant has negligently damaged the housing accommodation, but the landlord must live in the same property or immediately adjacent property. A demand provided under a quiet enjoyment or a nuisance theory must provide an opportunity to cure and must contain a description of the specific conduct that disturbed others or the specific conduct that caused a nuisance. If you get a demand, if you get a notice and you're then taken to court, part of the reason for the demand is to place you on notice as to, hey, this is a problem and it needs to be fixed. But you need to be told what that is. If you were just told a lease paragraph, you were not told the specific thing that violated that. So it's not placing you on notice of this is an issue and this is what needs to be corrected. There are some exceptions for under this theory. When a tenant lawfully exercises its rights pursuant to any law or rule relating to the occupancy of the property, that does not constitute any type of nuisance or does not create an interference with quiet enjoyment. And then also when a tenant's a victim of domestic violence, the victim of domestic violence does not disturb the quiet enjoyment or create a nuisance as a result of being a victim. Similar to a notice to terminate tenancy, here's kind of the general form you can pull off the state's website. This is JDF 99A. It's the demand for compliance. And again, on this demand, you can see that it has, you can see the spaces here. You've got to describe it. Comply with the lease, you have to describe it. Explain the conduct and the damages. So you've got to describe what it is. Even on a non-payment of rent, you have to say what dates the rent wasn't paid. So you just have to be given more information in these new documents. So what is the demand required? Again, specific description of the alleged violation, date and time when the premises shall be returned, be written in a language that the landlord knows or has reason to know is the primary language of the tenant. Right. So throughout these beginning slides, a couple of times I have used the phrase properly serves 90-day written notice. Properly serves. Well, let's talk about serving a notice or serving a demand. We've got the nice little neighbor fight there on whether or not something was served. And these new rules will help kind of address issues with service. So a notice or demand may be served on a known tenant occupying the premises, or by leaving a copy with some person, a family member above the age of 15. You can still serve by posting, right? But you have to try, it has to be more than just walking up and taping something to the door. In order for a landlord to serve a notice or demand by posting, they must attempt personal service at least once on 2 separate days. And then very quickly, for folks in a mobile home park, if your right to privacy has been expanded for a notice of entry from 48 hours to 72 hours. We're going to get into warranty of habitability. This is going to be a lot of the remainder of the presentation because these are issues that can come up quite frequently. We're also we all know what part of the year we're in. As the temperatures are starting to get colder, these are going to become this is very valuable information for folks. So the purpose of the warranty of habitability is to promote public health by ensuring that housing is safe and healthy. Sorry about that typo. It's also to protect tenants and to provide them with remedies for uninhabitable conditions. By entering into a rental agreement, there's this underlying promise, this underlying assumption that is implied that the landlord is deeming the premises to be fit for a human being to live in them, right? And that it will maintain habitability throughout the entire period the tenant lawfully occupies the dwelling. One thing to keep in mind here, it is lawful to occupy the dwelling until a writ of restitution is executed. So even if an eviction case is filed, it is lawful to occupy the premises until a court says otherwise and the sheriff executes that court order. We now have additional rules and additional kind of procedures when we're dealing with appliances subject to the warranty of habitability. So previously it had been limited more towards kitchen type appliances or any appliance promised in the lease. Now we have procedures for air conditioners, portable cooling devices, if we think maybe like a swamp cooler or something like that, permanent cooling device. Those are all now subject to the warranty of habitability. Right, there are some new definitions here. Extreme heat event is a day on which the National Weather Service has declared, predicted, indicated a heat advisory, excessive heat watch, or excessive heat warning for the county. A hotel room is one or more in a licensed or permitted commercial lodging establishment. Landlords now include both a landlord's successor in interest and the agent of the owner. Also, maintenance service now means service provided at the landlord's expense for purpose of maintaining, inspecting, repairing, ensuring the upkeep and preservation of the residential premises. But that doesn't apply to one-time specialized third-party contractors. All right, if somebody's coming out for a particularized service, they're not necessarily going to be maintenance service for purposes of the warranty of habitability. The importance of that will come into effect here when we start looking at new notice rules for warranty of habitability. And there's another new definition for organizing as well. We've got some more definitions to go through, folks. Remedial action. So when we're talking about how do we fix the problem, timely, what does that mean? Well, it means timely and good faith efforts to repair or remedy an uninhabitable condition at a residential premises or dwelling unit and to mitigate any negative effect of the condition. So if there's been a flood, it's not just coming in and clearing out the water. Look at that drywall. Is there water damage there? Is the property trashed from that? And you've got to fix that issue as well. Tenant now, so the definition of a tenant now includes any member of the household who has a right to occupy the dwelling or any individual who otherwise explicitly or implicitly has permission to occupy the dwelling. Written, writing, in writing. So if we're talking about something being in writing, something written, it means any record conveying information in a form that can be retained by the sender/receiver or can be displayed in visual text that can be retained. This includes paper, electronic, and digital. However, this definition of written, in writing, or writing does not apply to notice to terminate tenancies or demands. You cannot text message a notice or a demand. You cannot email those either. Those must be personally served or served by posting. All right, so let's talk about breaches of the warranty of habitability. So we've got a breach where the premises is uninhabitable by statute or if it, in a condition which materially interferes with the life, health, and safety of the tenant. But it's not just that. It's not just the existence of the condition. It's more than that. It's also, and the landlord has not started remedial action within the time period after having received notice. They started the remedial action, but they didn't continue it until the condition was fixed. They didn't completely fix the problem within a reasonable time after starting it or starting to fix the issues. They didn't comply with any requirements concerning damage from an environmental public health event. Or they leased a dwelling which is uninhabitable at the beginning of the tenancy. And when this situation occurs, if you move into a new place and it's uninhabitable from the start, you're not required to provide a notice. Because remember a few slides back, landlord, when they're entering into a rental agreement, the landlord is deeming that the property is fit for human habitation. So that implied promise, that promise that, hey, this is fit for y'all to be safe in, and you move in and it's immediately not safe, you don't need to place them on notice on that one. Okay? Now, notice eventually is probably a best action, but as far as trying to pursue perhaps injunctive relief before an order of specific performance, which we'll get to a little bit later. I don't have to retain those words right now. So there's now a rebuttable presumption in the warranty of habitability. When we're talking about a rebuttable presumption, that means that if X, Y, and Z are present, a court is going to presume, a court is going to say, hey, this is the situation until I hear otherwise. So in the warranty of habitability, a landlord is presumed to have failed to start to fix the problem, has not continued to fix the problem, or has not completely fixed the problem if the tenant can establish the following things: that the dwelling is uninhabitable, the landlord has notice of the uninhabitability, landlord has not communicated with the tenant after having notice within the required time frame, which is 24 hours, or the conditions continue to exist 14 calendar days after receiving notice if it's uninhabitable by statute, 7 calendar days after receiving notice if the condition materially interferes with life, health, or safety. All right, well, you've got the presumption, but can it be disproven? Yes, it can. It's a rebuttable presumption, meaning landlords are able to disprove that, okay? They can show that there's not this presumption of a breach if the remedial action was started and it was continued, but it couldn't be completed or finished for reasons beyond reasonable control. Or that this action fixing the problem requires us to get into the property and our tenant's not letting us into the property. So if you are dealing with uninhabitable conditions, do not refuse entry. You need these problems to be fixed. Also, it's going to stop the timeline of fixing the problem and keep that unsafeness in your home longer. Or the tenant engaged in conduct that unreasonably delayed or otherwise prevented remedial action from beginning within the required time period or continuing to completion or really fix the problem in a reasonable time. So as a tenant, you can't hinder the process. You want this process fixed. You want a safe home, so you've got to let the repairs continue. A tenant does not have to prove the breach by a preponderance of the evidence, or sorry, a tenant does have to prove a breach by a preponderance of the evidence in any kind of hearing. This presumption does not change that aspect. Landlords now have a duty in regards to their remedial actions. They have to reasonably continue to make efforts to start or continue fixing the problem. And these efforts can include correspondence and good faith cooperation with the tenant, talking to the maintenance staff, letting you know that these things can be done, any third-party contractors, any government officials, or any other person necessary to fix the problem. So a couple slides ago, we talked about what happens if, as a tenant, we don't allow the remedial action to start. We don't allow people to come in to fix these issues. Well, that timeline of how long someone has to fix the problem is going to be paused. It's going to stop that. It's going to be a timeout until the tenant proposes a reasonable alternative date and time for entry to conduct the repairs, or the landlord proposes a date and time and the tenant agrees to it. Now, let's talk about notices of uninhabitable conditions. Previously, we had in the statute talk about an electronic notice. Don't worry about that. That's deleted. That's no longer a thing. Notice is now any writing that provides the landlord to substantially know that the condition exists or may exist. We're saying any writing. Well, what does that include? That includes a written notice from governmental entity regarding the conditions, third parties regarding the conditions, a tenant concerning a condition that may affect multiple tenants. Think about like a larger apartment building. A tenant says, hey, I have bed bugs. Well, that landlord's now going to be on notice for really anybody around that unit that they're likely to have bed bugs too. It can also be a written notice from the tenant regarding the condition, which is sent in a manner that the landlord typically uses to communicate with the tenant. If you text messages can work. Also, tenants' written correspondence with maintenance staff or maintenance service provided by the landlord, including maintenance provided by a third party. This is communications with the maintenance staff now. So if you have a portal where you can submit work requests would now arguably place the landlord on notice of the uninhabitable conditions because you're communicating with the maintenance staff on the issues in your residence. Also, the last kind of catch-all here is written observations or reports that the landlord has obtained personally, directly, or indirectly. One of the main things here is that written notice has to be written down. That's text message, email, it has to be kept. So don't send a message through social media which is not retained or disappears after a certain amount of time. Generally speaking, don't do anything serious through social media communications. All right, so still on the warranty of habitability notice. So any notice is sufficient. It's got to be written, but any written notice is sufficient if it's provided to the landlord in a manner that is required or permitted by the rental agreement or any property rules or regulations pertaining to the premises. If the lease says you can do it X number of ways, that's fine. Also, I just went on my whole spiel about writing and being in writing. If the lease says it can be written or it can be verbal, it can be verbal. I would generally advise against that. I think that would be a bad practice for all parties involved because it will be really difficult to maintain that correspondence, but it's possible. And a written notice is valid if it substantially complies with all the requirements of the warranty of habitability. So through the notice, we've given the notice to our landlord is now on notice, whether that's through the governmental written notice, our correspondence with the maintenance staff, another tenant, or a third party. But either way, they're on notice. So what do they have to do now? Landlords are required to contact the tenant within 24 hours. That's extended to 72 hours if we're talking about an environmental public health event. If you're sitting there thinking, well, when are we going to talk about environmental public health events? We've got a definitional slide, but we're not talking about it today. I think if that happens, we're talking flash flooding, we're talking fires, we're talking mudslides, we're the environmental public health disasters. So the landlord must communicate the intentions to fix the problem, including when we're going to start fixing it and when it's going to end. As a landlord, you have to tell your tenant what the obligations are to provide an alternative residence, if applicable, and provide at least 24-hour written notice of entry if that entry is necessary to start or maintain the remedial action. When the condition is material and imminently threatens an individual's life, health, or safety, or an active and ongoing threat of causing substantial material damage, don't have to provide that written notice. You can just get in there and fix the problem. So, all right, landlords are coming in to start fixing the problem. Landlords must provide the date and time that they intend to enter the property. And they also have a reasonable estimation of how long landlord or that third party contractor coming in will need to be in the dwelling. As a tenant, you may reasonably deny entry into the unit at that date and time the landlord requests entry. The landlord then must propose an alternative date and time where tenant can do that, and the landlord can accept that. Also, tenants may permit entry with less than 24 hours. So, mentioned alternative residence. If a condition materially interferes with life, health, and safety, reported from the list of rebuttable conditions which materially interfere with life, health, or safety. We're going to get there. There's slides on that later. We just haven't gotten to those yet. Then the tenant can make a request, and the tenant makes a request for an alternative residence. It is not assumed you have to affirmatively make that request. Best practice is to make that request in writing. A landlord's remedial action then in fixing the problem must include providing a comparable dwelling unit or hotel room as selected by landlord within 24 hours at no cost to the tenant. The alternative residence must include the same number of beds as there are used in the residence. If you're in a 4-bedroom house, a hotel room with 1 queen bed is not an alternative residence. Also, now, if we are in an alternate dwelling unit for more than 2 days, that unit must include a refrigerator with a freezer, a range stove or an oven, or landlord must provide a per diem for incidentals and daily meals for each tenant and an amount at least equal to Colorado's state employee per diem for intrastate travel. And must provide that per diem to the tenant at the time the landlord reasonably expects the tenant to be in the residence for more than 48 hours, and then for every 24-hour period after. Then the alternative residence. This may seem like a silly assumption, but it has to be habitable. We just were taken out of an uninhabitable place. The place we're going to be put in must be habitable as well. It has to be accessible to individuals with disabilities. It also has to be located within 5 miles of the original dwelling unit, unless the tenant agrees to an alternative dwelling more than 5 miles away. A landlord may select a residence, an alternative residence 5 to 10 miles away if it's substantially less expensive than options within 5 miles. If an alternative residence within 5 or 10 is not available, the landlord must select the nearest available comparable alternative residence. What about expenses that come up in this alternative residence? Landlords are required to pay relocations expenses to the tenant for the per diem previously mentioned. Also, any reasonable costs incurred due to the relocation, including storage and transportation costs. Tenants remain responsible for the rent. throughout this time period as well. Now, hotel rooms, there are some limitations on a hotel room as an alternative residence. If the condition cannot be completed within 60 days due to circumstances outside the reasonable control of the landlord, then they may not have to continue to provide hotels accommodations. If landlord determines the condition can't be fixed within 60 days, and it's beyond my reasonable control as to why it can't be fixed within 60 days, provides the tenant the earliest opportunity, a written notice that specifies the condition cannot be fixed in 60 days, the date when the hotel accommodation will no longer be provided, and that the tenant may terminate the rental agreement with no liability or financial penalty, and returns full security deposit to the tenant on or before the date on the notice for the end of the hotel accommodation. There's also now, and landlords now have a duty to maintain records related to the warranty of habitability as well. So it shall maintain accurate and complete records of all written notices and correspondence and all documentation relevant to any condition or remedial action taken to fix a condition. If you've got old phones with text messages on them, you got to keep them. These records must be maintained and retained for at least 3 years after the tenant moves out. And the landlord shall provide to the tenant upon their request any record, any notice, or any correspondence of other documentation within 10 calendar days of the request. As far as costs of repairs, the remedial action, landlords are responsible for the cost of the remedial action so long as they receive notice and the uninhabitability was not caused by the tenant's misconduct. Misconduct does not include uninhabitability where the condition was caused by an act of domestic violence, unlawful sexual behavior, or stalking. Here's the definition for environmental public health event. And here are the processes for it. I'm going to skip over these, that way we can hopefully, so we can get to more questions today. Again, we're dealing with, receive these slides, but if you're dealing with that type of environmental public health event, here's the information on how you'd be able to terminate the lease early. But let's talk about our old friend mold. So for the warranty of habitability, mold means mold associated with dampness in a dwelling unit or any other condition causing the premises to be damp, which if it's not fixed, it could create mold or materially interfere with the tenant's life, health, or safety. We don't have to wait until the residence looks like that. Okay. A landlord must begin remedial action within 24 or 72 hours, depending on the nature of the demand. Again, here's the process for what needs to happen when we're dealing with mold. So if a landlord's placed on notice of mold in a property, they have to start taking action. They need to install a containment stopping active sources of water contributing to the mold, install a high efficiency particulate air filtration device to reduce exposure. They also must maintain that containment throughout the remedial action and repair, establish worker and occupant protections that may be appropriate given the conditions, limiting moisture sources, drying all impacted materials, decontaminating and removing damaged materials, evaluating whether the remediation has been successful, including testing for mold, and then reassembling the premises to control the moisture, hopefully to prevent or limit any recurrence of this in the future. If the mold would interfere with the life, health, or safety of a tenant, and the tenant makes a request for an alternative residence, then the landlord must provide an alternative residence. Got some rental insurance rules. Landlords shall not require a tenant to submit a claim with rental insurance to cover a cost or expense related to remedial action for an uninhabitable condition that the landlord is responsible for. If your place is uninhabitable, you do not submit a claim to your renter's insurance. Landlords are prohibited from filing a claim with the tenant's rental insurance to cover their costs or expenses related to an uninhabitable condition that they are responsible for remedying, unless they've received express written permission from the tenant at the time the claim is submitted. All right, now we're actually going to talk about the conditions. We've gone through the notice, we've gone through mold. So what conditions are covered by statute? We've got water, There must be running water at all times, hot water at all times, in an amount necessary for the tenant to perform all ordinary activities related to maintaining cleanliness and health. Shower, cooking food, boiling water, etc. Infestation now includes pests and insects, in addition to rodents and vermin. Trash. So landlords are required to provide an adequate number of trash receptacles. In addition to providing the trash cans, they must be scheduled to be serviced and emptied at sufficient intervals to ensure containment and proper disposal. So the trash needs to be picked up, not just the trash can sit there. Elevators must be maintained in good working repair. There must be compliance with any and all radon requirements. Also, there must be compliance with all requirements related to cooling devices. Also, otherwise unfit for human habitation is kind of somewhat of a catch-all there. If there's a reason that isn't explicit in the law, but it, one of those where, well, this isn't safe, that's what that last one there would be for. The other conditions are still in effect. If you look through your packet, if you have that, you'll see other conditions listed in there. These are additions to them. So not going to apply to anybody in this room, but in about 4 months, when leases are being handed out in 2025, they all must include in 12-point bold type that every tenant is entitled to safe and healthy housing under Colorado's warranty of habitability. Landlord is prohibited from retaliating against the tenant in any manner for reporting unsafe conditions in the premises, requesting repairs, or seeking to enjoy their right to safe and healthy housing. It also must include an address where the tenant can mail or personally deliver written notice of an uninhabitable condition, and an email address or online tenant portal platform where they can deliver written notices of uninhabitability. If we're talking about an online platform, it must have a statement in English and Spanish that says the address where the tenant can mail or deliver a notice. So, talked about one rebuttable presumption tonight. We're now going to talk about another one, and this is related to life, health, or safety. So I would have described this as a gray area before, where it was there, but it wasn't defined. Now we have conditions which, if present, a court would presume that they materially interfere with the life, health, or safety of the tenant. Lack of waterproofing or weather protection for the roof, exterior walls, exterior doors, exterior windows, so that weather can enter the premises. You can see outside where you're not supposed to, that's a problem. Any hazardous condition of gas piping, gas facilities, gas appliances, or other gas equipment. Inadequate running water, inadequate running hot water. The exceptions here are if it's a temporary disruption due to necessary maintenance, necessary repairs, or necessary construction that is being performed, or the temporary disruptions in water service that a landlord could not reasonably prevent or control. Lack of functioning heating facilities and heating fixtures installed and operating in compliance with the law when installed and maintained in good working order from October through April. All right, if your heat goes out October 1, there's a rebuttable presumption that the premises materially interferes with your life, health, or safety. Any hazardous electrical wiring, electrical facilities, electrical appliances, or electrical equipment. Lack of electricity or disruptions caused by the landlord's failure to maintain the electrical wiring, facilities, appliances, and/or the equipment. Got an infestation of rodents, vermin, pests, or insects. That's going to be a rebuttable presumption that the property materially interferes with your life, health, or safety. If you have inaccessible fire exits or egress in accordance with applicable building, housing, fire, and health codes, it's going to materially interfere with your life, health, or safety. Because, well, if you can't access your fire exit, that's a problem. Any missing, damaged, improper, or misaligned chimney or venting system on any fuel-fired heating, ventilation, or cooling system. When the elevator is inoperable and the tenant has a disability that prevents the use of the stairs or relies upon the elevator to access the dwelling and there are no other operable elevators that provide access, well, kind of trapped then. either inside in your residence or out of your residence. So that's going to materially interfere with your life, health, or safety. Oh, again, this is a rebuttable presumption. This is not something that is ironclad. So if a tenant establishes this presumption, a landlord can rebut it, and they can rebut this by demonstrating by clear and convincing evidence, which is a higher legal standard than preponderance of the evidence, that the condition does not materially interfere with the tenant's life, health, or safety. However, even if a landlord is able to rebut this presumption, that does not prevent a court or a jury from finding that any condition or combination of conditions described materially interferes with a tenant's life, health, or safety. That would need to be proven by a preponderance of the evidence, which is a lower evidentiary burden than clear and convincing evidence, which is how that situation could occur. I've mentioned portable cooling devices and air conditioners a couple times, so let's talk about them a little bit more. Landlords shall not prevent a tenant from installing a portable cooling device unless the installation would violate building code, state law, federal law. It would violate the manufacturer's written safety guidelines for installation and use. It would damage the premises or render the premises uninhabitable or require more amperage to power the device than can be accommodated. If a landlord restricts the installation or use at a premises with multiple dwellings, then the landlord shall prioritize a request for a reasonable accommodation for a portable cooling device over a regular request for one. If we have restrictions on installations or use of a portable cooling device, an air conditioner, then landlords must disclose any restriction to the tenant or an applicant, a prospective tenant, in writing. Also provide information about whether the landlord intends to operate common spaces that will be cooled by a portable permanent cooling device and would be available to a tenant during an extreme heat event. If there is not a common cooling space, the landlord must provide information on community cooling spaces near the premises that are accessible to the tenant. Not required to provide information if no such spaces exist within 10 miles. When we're talking about a community cooling space, what does that mean? It means public spaces available to a tenant that are located on or near the premises and maintain a temperature not higher than 80 degrees. Rec centers, community centers, public libraries, these may all kind of fall under that type of umbrella. Oh, we're still in the warranty of habitability. We've established a breach. And as a tenant, we're saying, hey, I want to terminate my lease now. My home is not safe for me to live in. How would I do that? So can terminate a rental agreement without any liability or financial penalty if the uninhabitable condition remains by providing 10 to 60 days written notice, which must state the uninhabitable conditions remain. I intend to terminate the lease and I'm going to vacate the unit, and the date I intend to vacate the unit. That date must be at least 10 days after providing this notice, but 60 days or less. So you can't say I'm going to move out in 3 months. That's not okay. It has to be more than 10, 60 or less, somewhere in that time frame. If you give this notice and then your landlord fixes the problem and now you have a habitable residence, prior to that termination date, then you may agree in writing with your landlord to rescind the lease termination and continue the rental agreement. You do not have to. Also, if we're dealing with a recurring condition, something that has happened more than once in 6 months, you can provide a notice of 30 days of uninhabitability, which is 10 days written notice that the same condition has recurred and that the date that you intend to terminate the lease agreement. If it's happened within 2 times, if it's happened 2 times in 6 months, you can just terminate without any financial penalty. Same thing, however, if the issues are fixed, then if the issues are fixed before the lease termination date, you may reach an agreement to remain in the residence and continue the rental agreement. What about rent deductions? Right, so this is a detailed process. If you're dealing with the warranty of habitability and uninhabitable conditions, and you think I'm going to start withholding rent, please make sure that you have a firm grasp of what you're required to do in this process. You may deduct from one or more rent payments the cost of repairing or remedying uninhabitability if you provided 10 days advance written notice of your intent to hire a licensed or otherwise qualified professional to fix the problem, except it may be 48 hours notice if it's a good faith belief about material interference with life, health, or safety. Your landlord then fails to sufficiently fix or repair the problem within the time provided by the notice, or fails to provide an alternative residence. The professional that you intend to hire is not related to you, and the professional provides an estimate that is reasonably consistent with industry standards. The tenant hires the professional to do the work, and the tenant provides the landlord with a receipt, invoice, proof of payment for the work completed within a reasonable amount of time after completion of the work or within 30 days after the landlord requests such documentation. Again, this is a specific process to go through. Make sure that you're following the process correctly if you're choosing to deduct rent. What about appliances? So instead of repairs, a tenant may replace a broken, malfunctioning appliance and deduct the cost from one or more rent payments if it provides at least 3 days advance written notice of the intent to purchase and replace. The landlord fails sufficiently repair or replace the appliance within the notice period. The replacement appliance is of comparable quality and substantially the same features, and the tenant provides the landlord with a receipt, invoice, proof of payment within a reasonable amount of time or 30 days after the landlord requests the documentation. I always like to use kind of smart refrigerators as an example here. So if you've got a refrigerator that doesn't, tell you the weather, say to you in the morning, like I do, and it breaks, and you go and you buy a singing fridge to install, and you try to deduct that cost from your rent. I don't know if that's a reasonable replacement. Also, keep in mind, you're not taking that refrigerator with you in that situation. It stays in the property. So if we've got multiple months of deductions, if that's made over 2 or more rental periods, the tenant's only required to provide one notice of the intent to deduct rental payments. Just make sure that you're clearly writing out that notice. That way, if your landlord receives it, they understand what the deductions are going to be for the months listed on it. What about a wrongful deduction? And so this is what I'm harping on. This is a specific process. Make sure that you're following the process. Landlords may pursue any legal remedy available under the law for a tenant who wrongfully deducts by not substantially complying with the statutory requirements. If a court finds that the wrongful deduction was purposeful, then the court shall award the landlord damages equal to double the amount of money that was unlawfully deducted. So we have uninhabitable conditions. We've incurred, maybe they've been fixed, but either way, what kind of relief can a tenant seek from a court when we're dealing with uninhabitable residences? So it can be a claim on it, it can be a standalone lawsuit, or it can be a counterclaim in a court of competent jurisdiction, and a tenant may recover actual damages directly arising from the breach. Actual damages includes a reduction in the fair market rental value during the period of inhabitability. And a tenant may also recover court costs, reasonable attorney fees, punitive damages if the actions rise to that level, and any other damages as ordered by the court. Right. Now we're into a very new addition this year. And this is a preliminary or permanent injunctive relief for a breach of the warranty of habitability, which can include an order for specific performance. So what does that mean? It's a lot. It's a word salad on the screen right now. It means you would go to court to get the problem fixed. Get a court to say, I need electricity. I need a roof. I need heat. If injunctive relief or an order of specific performance is given, the court's jurisdiction continues until compliance has occurred. That means that if you get an order for your landlord to fix something, the court's going to keep that case open to make sure that the order's followed through. So I mentioned order here a few times. What can that include? To remedy any existing violations, including relief to similarly situated tenants. We think back to those bed bugs in that apartment. Similarly situated tenants, going to be the units around them, all right, who are reasonably likely to be affected by the condition. For the landlord to modify or cease practices that give rise to a violation, and for the landlord to adopt policies, practices that ensure compliance with the warranty of habitability to minimize or eliminate the likelihood of future violations. The court may determine actual damages for the breach at the time of the order or at a later time if they deem that to be appropriate. If the damages are going to be ongoing, they may set that determination over for a future proceeding. If landlord pays those damages to the court and the tenant makes an application for the release of those funds, the court shall immediately release the damages paid to the tenant. If the tenant vacates the residence based upon the uninhabitability, the landlord shall not rent the premises until the unit is in compliance with the warranty of habitability. And that kind of closes the loop from where we started a little bit ago, that when you enter into a rental agreement, it's deemed to be fit for human habitation. Well, there's temporary restraining orders which can be issued for a breach. So this is an immediate temporary restraining order without notice to the landlord, this in any county court or district court, which shall require the landlord to provide a habitable dwelling. This isn't a restraining order or protection order if you think of that in a domestic violence situation. This is the court telling the landlord, you need to stop creating this uninhabitability. Request for the immediate temporary restraining order that requires them to comply may be issued by the court if the court finds specific facts from an affidavit, from a verified complaint, or from testimony, any of those three sources. And if they find specific facts that the dwelling is in a condition that materially interferes with life, health, or safety, landlord had notice, landlord failed to comply, and the tenant certifies to the court in writing or on the record any efforts they have made to obtain the landlord's compliance with the warranty of habitability. Communications, emails, any offers that may have been made to speed the process along would be required for a court to make that finding. This request for a temporary restraining order may be granted, dissolved, modified in accordance with the rules of civil procedure, but a tenant is not required to post any kind of bond, security, or show proof of damages, proof of loss, or proof of irreparable injury. You don't have to wait until your roof collapses on you to get it fixed. A court shall consider and rule on such a motion at the earliest possible time, and these motions take precedence over all matters except older motions for a temporary restraining order. This is the motion that the court drops everything to address, because you are living in a place that is materially interfering with your life, health, or safety, and it's not being fixed. A breach of the warranty of habitability is a defense against an eviction. It is also a defense against a collections action for money after a tenancy. This defense can be raised in an answer. It can be raised in a pretrial court filing. Courts are required to liberally construe a tenant's answer or other filing to determine whether the breach is raised as a defense. These new laws mean that if you don't have heat, and you tell the court in your answer that I've been without heat for 6 months, I told my landlord I don't have heat. While you didn't cite all of the statutes, a court's supposed to read that and say, this person says they don't have heat. That's a problem. And then they gave notice. So they're supposed to construe that as you're raising the defense of the warranty of habitability. You're not required to post any kind of bond, to have accrued any expenses related to this breach, or to have used any other remedy in response to the breach to be able to use it as a defense. If you didn't seek a temporary restraining order, it's still available as a defense. If it's raised as a defense, the court shall order the landlord or tenant provide any documentation relevant to the breach that either party requests at least 96 hours before the day of trial. This documentation may include records, notices, reports, correspondence, and other documentation maintained by the landlord. If the landlord fails to provide all relevant documentation, then the court shall continue the trial, and repeated failure may be good cause for appropriate sanctions against the landlord. What would those sanctions, if you're thinking, well, what are the sanctions? It could be that the court draws an inference that the landlord is not producing this documentation or the tenant's not producing this documentation because it says something they don't want it to say, because it says a bad thing. The court may limit or prohibit documents if a party fails to provide them without good cause, and the delay in providing documentation would substantially prejudice the opposing party. So the defense against an eviction. So we're going to talk about defense against non-payment. If within 60 days before or at any time during the period in which the tenant is alleged to owe rent or any other monetary amount due pursuant to the rental agreement. Let's stop on that for a second. If 60 days before or during the period of non-payment, there's uninhabitability, the warranty of habitability would be a defense. It would also be a defense that at any time during the tenancy, and the uninhabitable condition continued to exist into the period in which the tenant is alleged to owe rent or the monetary amount due. The tenant does not need to show that the uninhabitability exists at the time of the trial, just either leading up to the alleged non-payment or within 60 days before or during the period of alleged non-payment. What about reasons other than non-payment of rent cases? That's still a defense as well. But has to demonstrate that the alleged non-monetary lease violation, that allegation that a material condition, that a material covenant has been breached, arose from a breach of the warranty of habitability. This is not a defense if a landlord proves the tenant committed a substantial violation. If a tenant proves the affirmative defense to the court of the warranty of habitability, then the court will deny possession to the landlord. It will deem the tenant the prevailing party, which means they won the case, subject to payment of rent owed. If it's a non-payment of rent case, and the court finds that there was a breach of the warranty of habitability, the court is then going to determine what the rent is due for that period of time and give the tenant 30 days to pay that amount. We're also going to order the landlord to repair or remedy any existing uninhabitable condition within a specific time frame and order a reduction in rent backdated to when the uninhabitability began until the condition was fixed. That amount of rent that is owed could be zero. I don't know. That's going to be a case-by-case basis. Again, if this is proven, the court's going to order the landlord to reimburse the tenant any difference in rent paid and the reduced rent ordered by the court. Determine and award actual damages to the tenant, but the tenant may continue that hearing to determine the full scope of actual damages, award the tenant costs and attorney fees, and determine whether the landlord has proven that any outstanding rent is owed after the reduction in rent, and also deducting any other expenses incurred by the tenant or actual damages, also attorney fees and court costs, and any monetary damages from separate counterclaims asserted and prevailed on by the tenant. All right, so defense is raised, but it is not proven. What happens here? So this is where there's an eviction hearing, and at the end of that hearing, the court rules in favor of the landlord and tell the tenant, you have not proven the warranty of habitability. I am ruling in favor of the plaintiff here. Even in that situation, the court has to provide the tenant with 14 days to pay the landlord or the court the rent that is owed to the landlord. If the tenant pays the amount ordered, then the court shall dismiss the case with prejudice. So if you raise the warranty of habitability as a defense, and the court disagrees with you and rules in favor of your landlord, you will have 14 days to pay the rent. If you pay the rent within those 14 days, the case will be dismissed with prejudice and your tenancy will continue. If a tenant fails to pay, that's when the court would enter a judgment for possession at that time against the tenant. If the court determines that the tenant raised the defense frivolously, meaning you had no good faith to bring this before the court, or for the purpose of delay, then there will be no 14-day waiting period, and the court will enter that judgment for possession after the trial. So what's the fair rental value for an uninhabitable dwelling? Again, folks, we're talking about a rebuttable presumption again here. We're back in that fun world. So the fair rental value is rebuttably presumed to be the following. It's $0 when we're talking about a condition that materially interferes with your life, health, or safety. The place is dangerous to your life, place is dangerous to your health, place is dangerous to your safety. It's not worth anything. It's 50% of the rent for other conditions which render the dwelling uninhabitable. Again, this is a rebuttable presumption. This can be rebutted by evidence from the landlord showing there is a value to this. If it's a material interference with life, health, or safety, there's a value beyond $0, whatever that may be. Be case by case. I don't have any further guidance on that. What about attorney fees? If a rental agreement allows the prevailing party to seek attorney fees, and if the court determines a prevailing party for an action brought pursuant to the warranty of habitability, then the party may recover reasonable attorney fees. Landlords may only cover attorney fees and costs if the court finds that the tenant filed a frivolous complaint or counterclaim under the warranty of habitability. So we now have, if you have a lease that you entered into after May 3rd, there are some things that are no longer allowed in leases. So you can't waive, modify, or restrict any of the rights regarding the warranty of habitability, or charging any cost, charging a fee, or assessing some kind of penalty because the tenant exercised or attempted to exercise a right or a remedy. So landlords can defend against a claim of the breach of the warranty of habitability. And it's a defense against a breach if the landlord is able to show that the tenant refused to provide, refused to accept a proposed reasonable alternative date and time for entry into the dwelling, unreasonably denied entry into the dwelling, or engaged in any other action or inaction that unreasonably delayed or prevented the landlord from starting, maintaining, or completing the remedial action. And the tenant's actions made it impracticable for the landlord to reasonably remedy or repair the condition. And if you're saying as a tenant, that this makes sense, because if you're saying my place is uninhabitable, but you can't come in, that doesn't really mesh. So briefly on to retaliation here. Landlord shall not retaliate for making a good faith complaint to the landlord, a nonprofit organization, or a third party, or to a governmental agency alleging an uninhabitable condition. Can't retaliate for organizing or becoming a member of a tenants association or similar organization, or exercising or attempting to exercise in good faith any right or remedy afforded to you as a tenant under the warranty of habitability. That statute right there, 38-12-507, that's the warranty of habitability statute for a tenant's remedies. What does retaliation mean? Increasing rent or decreasing services, terminating or not renewing a rental agreement or a contract without the written consent of the tenant, bringing an eviction action, or threatening to bring an eviction action. Taking action that in any manner intimidates, threatens, discriminates against, harasses, or retaliates against a tenant. Charging the tenant or seeking to collect from the tenant any fee, cost, or penalty. That doesn't mean that late fees can't be applied, but we are talking about retaliation, and we're in the warranty of habitability sphere here. So I don't want that to be construed as landlords are not able to charge a tenant any fees or costs or penalties, but there are avenues where that will be construed by the court as retaliation when we're talking about complaints of uninhabitability. Retaliation would also be a defense against an eviction based upon non-payment or or a alleged violation of a material condition or covenant. It can be a defense against a notice to quit, a notice to terminate tenancy, or a notice to vacate. It can be a defense of an expiration of the tenant's rental agreement, or the non-payment of rent resulting from a retaliatory rent increase. If this is going to be the defense, it does not need to be the only reason. The complaint of the uninhabitability does not need to be the only reason that the retaliation occurred. The tenant just needs to show that it was a motivating factor that influenced the landlord's decision to take that retaliatory action. So it doesn't have to be the whole thing, but it has to be an influencing part of it. Then if the landlord does retaliate, and the court finds as such, a tenant shall recover damages in an amount not more than 3 times the rent or actual damages, whichever is greater, plus reasonable attorney fees and costs, and they also may terminate the rental agreements as well. All of these new rules and processes that we have discussed can be enforced by the Attorney General. The AG's office may start a civil action against a person that has committed or is engaging in a pattern or practice of violating the warranty of habitability, may intervene by right in a civil action in any court that involves the warranty of habitability. So the AG may put, this is talking about their priorities here, not really going to go through them word by word. Also, the AG may seek, apply for, or obtain a temporary restraining order, injunction, or both. They may also accept assurances that a practice will stop. They may seek civil penalties on behalf of the state of up to $20,000 for each violation of the warranty of habitability, and a civil penalty of not more than $10,000 for each violation of a court order or any injunction. These penalties are then added to the Colorado's general fund. All right, I actually was able to get through that with plenty of time for questions. All right, I will work my way through.
You unmuted?
Yep, we're unmuted.
We're live. We're live.
Hello, Mr. Albert, can you hear me? My name's Jody White, by the way.
Hi, Jody.
You might know me. I just wanted to say hi, and everything, you're very, very clear and concise with this. It's awesome.
Thank you, Jody. Thank you. Jody, I'll give you a call tomorrow.
Okay. Anybody else have questions?
I have a question. When you said that the living environment, the dwelling could or would or is a danger to the tenant, do you mean inside of the dwelling? You know, there seems to be a lot of shooting right outside of our apartment quite a bit. So, you know, we're kind of worried about getting shot all the time. Would that fall into that category?
They can't.
Not fall under that category because that is something that would be outside of the landlord's reasonable control. If we kind of think about that, control the general public. Right?
That's what I thought. Thank you.
All right, I'm going through the chat here. I don't
think there are any in the chat.
Okay. I don't see any questions in the chat, but folks here in the room. All right, first hand up.
I had a question. My landlord is charging a building maintenance fee. Is that?
So you're now going at I'm not trying to be rude, ma'am, but you're asking for legal advice. So when you're asking me to apply the facts of your situation, like my landlord has charged me with a building maintenance fee, you're then asking me to apply the facts of your individual circumstance to the law and return that opinion to you, which I would love to do. That's not the proper place for this afternoon. For me to be able to provide legal advice to an individual, you've got to apply for CLS services for me to be able to have the availability to take on the case. I'm not trying to shut you down, my own mayor. You started with the key kind of word there. I'm like, uh-oh, red flag alert. We're now asking for advice. I have to be careful here, okay? But generally speaking, on items or fees or costs in a lease, the broader answer is it depends. So that question in a vacuum, because my first question back is, I want to review the lease. And that's why I can't answer those kind of questions in this forum, because there would be, I'd have to review the documentation and then apply that to the law to determine what would be proper and what would be improper in that situation. And for folks online, the question was regarding a building maintenance fee that someone here in the room is being charged by their landlord.
And there was a question we received in advance that did mention a whole list of different kinds of fees. Is there any general, like, I don't know, laws regarding how many and different kinds and total amount of fees?
It's gonna, so the question, thank you, Barb. The question is, are there, what are generally kind of rules on fees or charges? All right. Late fees are very specific. They have their own set of rules, okay? You also can't be charged liquidated damages. What are liquidated damages? Case by case, have to read the lease. You cannot be charged any kind of fee to recoup your landlord's portion of mandatory mediation if that were to occur.
Cleaning supplies.
Cleaning supplies.
Like if the landlord withholds the
security deposit. So security deposit and cleaning, kind of pre-scheduled cleaning fees. Now, I don't know about pre-scheduled cleaning fees. The way that the way Colorado statutes look at security deposit issues is landlords are able to keep or retain portions of the security deposit or the entire deposit for unpaid rent, unpaid utilities, work contracted for by the tenant, and damage beyond normal wear and tear. So these cleaning fees would likely either fall under beyond normal wear and tear, but you'd have to prove that those damages were actually incurred. There could be an argument that those cleaning fees, that schedule, maybe weren't contracted for you as the tenant because you were then signing that contract to move in. So it's tough. Again, these questions are difficult to answer in a vacuum without having the actual terms of the lease. And if you say, well, I got my lease right here, I'm going to say, great, please apply.
For folks who, sorry, I didn't mean to jump in, but just for folks who have issues that you're thinking, I don't think this is legal or this is not okay. Like somebody asked this question about the, not getting any of their security deposit back because they think they should have gotten it back. And the reason the landlord, so in a case like that is a person's recourse basically to, if the landlord won't talk to them or if they can't talk to their landlord, then try to apply for services through legal services, or what else can people do?
Well, and that's a great question. And this is a broader issue or a broader area of housing that hasn't really been affected by any big changes in the legislature, which is security deposits. So very briefly, security deposits are the money that we pay as tenants upfront to ensure that we follow through on the lease. And our lease, by law, the deposits are supposed to be returned to us minus any lawful deductions within 30 days. However, your written lease agreement can extend that time period up to 60 days. When you move out or you vacate, you must provide the tenant with a forwarding address. Your landlord is only required to send that deposit, your security deposit or accounting statement to the last known mailing address. Let's walk that out. Where did you just move out of? The place that they rented you. If you don't give them your new address, they only know the address that you definitely don't live at, which is the one you just moved out of, right? If you receive a deduction statement and you disagree with those reasons, the process is that you have to provide your landlord with a dispute letter demanding the full return of your deposit. You have to provide them 7 days to return that deposit. After that 7 days has expired, at that point in time is when you you potentially have a claim for the wrongful withholding of the security deposit to bring to court. If, however, you get to that point, you send the demand letter and you get no response, court is the only option at that point. So it kind of funnels to a court action. And in a small claims action, if a court finds that the landlord has willfully, wrongfully withheld the deposit after receiving that demand, then the court is able to impose what are called treble damages, which means they would award 3 times the wrongfully withheld amount of the deposit. Yes, ma'am. Coming over to you, sir.
I wanted to ask you, I'm not sure how, specifically related this is, but with NSF fees.
Non-sufficient fund fees.
Right. I recently learned, or I think I learned that Colorado has a limit on what can be charged for that, and it's $20. Are you aware of that?
Well, I'd have to circle back with you on that one to get an exact statute site. I don't have that memorized off the top of my head right now. That could exist in a consumer code, but it would be one where I'd have to do a little bit more research.
I've read it, and that's what it says. So I've got a property manager that believes that the corporate policy, overrides anything the law might say.
That's great. Judges love it when they hear my policy overrides your law.
Yeah. What would you do in a situation like that? I'm sure I'm not the only one.
I mean, you'd almost, again, since we've gotten so factually specific at this point, I'm not trying to be rude.
Right.
But
I mean, can I file small claims?
I can't give you my advice right now. Yes, sir.
Is handicap parking considered part of life, health, and safety? And if it's required for your particular apartment, is it based on the length of your lease? If they don't comply with that adequately? Let me give you another example. There are handicap parkings in.
I know you're about to go into a very fact-specific example to what it is that you're going through right now. As far as just generally, with a handicap spot.
What I'm saying is handicap spots exist around various parts of the complex, just not in the particular building that is affected by the tenant.
And they're all different sizes.
And they're all different sizes. So my question is, it's been contacted through it's been communicated through fair housing, and they said that they don't have jurisdiction. So who does? Is that code enforcement, or who enforces that law for handicap, disabled, ADA parking and so forth?
CCRD.
CCRD?
Rights Division.
Oh, yeah. Beyond that, in that type of situation, so it'd be the Colorado Civil Rights Division with the Attorney General's.
Okay.
But sometimes those issues can be resolved with a reasonable accommodation letter.
Okay.
Reasonable accommodation, and we didn't get into this in this presentation this evening, folks, but when we're talking about fair housing issues, if there is a change, an alteration to a policy, a procedure, or part of your residence that is kind of depriving you of the full use and enjoyment of your residence, you are able to submit a reasonable accommodation letter to your landlord. The reasonable accommodation letter indicates that, I suffer from a disability. I would require an accommodation, meaning I'm asking you to change one of your rules, your policies. I'm asking you to make this exception so that I may have full benefit and use of my residence. But you have to make your specific request for the accommodation, such as I am requesting in this situation, X parking space, X location to be X size.
That was done and they failed to comply. So
now we're getting way too fact specific.
Okay, I have a general question that I'm sure as a resident of Colorado and a native of Colorado is probably something that a lot of people are running into. Marijuana is obviously legal in the state. Can somebody explain to me how all these complexes use the Clean Fair Act as a reason for us to smoke outside when Colorado state law says we need to be inside or in a place where we cannot be seen. I need to know why from complex to complex does their MMJ laws change, but the Clean Air Act is the same in every complex.
True. Yep, that is true. They say don't buy marijuana in our apartment.
Unfortunately, so I also want to see. I don't have the information available to be able to properly answer.
I'm not asking for a direct question. I'm asking for this to be studied so that next time this question does come up, we have some kind of information that other than we just don't know. Because this is a problem that I'm having as a consumer. I'm 56 years old, so obviously I predate the MMJ laws, and I catch more flack behind my housing now that it's legal than I ever did before it was illegal. And it varies from complex to complex because I just recently moved and had to do a whole lot of unexpected information gathering, where these things change from complex to complex. And a lot of these complexes are owned by outside entities that are not in this state. And they think that their rules supersede my rights as a Colorado resident. So if this is the place and space to find out these answers, I would like this question to be posed as a question that needs some answers.
I might be able to help a little bit.
Could you please?
Is your apartment, I'm sorry. Go ahead.
Does anybody have other questions about the renter rights presentation? Oh, I see it.
Chat.
Okay, so question in the chat is this a fee that would stand up in court? Maintenance coordination fee, $280. Is charged when landlord must coordinate tenant responsible vendors. I don't know. Again, and folks, I'm not trying to be a broken record here, but this is part of the reason why I can't give legal advice in these settings is if that's the full lease clause, I'm not really sure what it's referring to, and I would need to read the lease. Yes, ma'am.
So when you did mention about like bed bugs and what are the steps? So if they sign the lease,
okay,
and then they come back into the home after they sign the lease and they sleep one night, 24 hours, and there's bed bugs. What are the steps? Do they need to seek legal advice, or do we need to refer them back to the landlord so they can terminate their lease?
So for bed bugs, they must provide the landlord with written notice that they believe that there is an infestation. The landlord is required to take prompt reasonable action. That's going to include scheduling an inspection.
Do you know how long that takes, like within a time frame?
Scheduling.
The question for folks online too.
The question is regarding bed bugs for the folks online and the time frame in which a landlord would have to schedule an inspection for said bed bugs. As also shown in the alternative residence slides, one of the things that would have to also be completed would be that they would have to provide an alternative accommodation based upon that. Give me 1 second. I will get the response for you on.
Been here since one.
But while I'm here we go. All right, when we're dealing with bed bugs, as a tenant, you have to promptly notify your landlord that you reasonably suspect the dwelling unit contains bed bugs. Then within 96 hours of that notice, you must provide the tenant with a 48-hour notice of your intent to enter the dwelling. You must also obtain an inspection by a qualified inspector. At that point, the landlord may also enter the dwelling unit or any contiguous unit for the purpose of inspection. And if the inspection confirms the presence of bed bugs, then you have to inspect all of the other connected units. Landlords are responsible for all costs with an inspection and for treatment of bed bugs. Tenants are going to be responsible for all costs in getting the property ready for that treatment. Like if tubs have to be purchased to put everything into, if things have to be kind of pulled back to the wall, that's the tenant's responsibility to prepare the residents for the treatment. After the inspection, landlords have 2 business days to provide the inspection report telling the tenant whether it does in fact contain bed bugs. And then if it is confirmed that bed bugs do exist, then within 5 business days after the inspection, you have to start treatment. Yes, ma'am.
You mentioned stuff about making sure you get notices and stuff and put it in writing. If the tenant does most of the writing because they don't have a computer to go through the channels that the landlord wants you to do, go through their communicated portals and do things online. And if you continue sending them written notices and they don't respond to you because they want you to go to the computer and you don't have one, is that something that we can address somehow?
Possibly, if your lease provides that you're allowed to provide these written notices, then you're allowed to do that. And if they're not being responded to, then I can't say that there would be any, I can't say for certainty what would be the proper action to follow up with. But if we're talking about the warranty of habitability, then it's possible that there's a breach involved if there's no response. We've got about 9 minutes left. Yes, sir.
Can you comment on resident benefits package? Do you need legal advice to comment on that? We're forced to pay extra for these special benefits.
Mm-hmm. So in my first response is I would have to see what they would be. Say I have my lease here, but unfortunately today wouldn't be the right kind of venue for that. So if you want to take down a statute, CRS 3812-801 lays out what lease clauses would be prohibited. So that if you want to do kind of some digging on some research, it'd be 3812-801. If you have the packet, that should be described in there as well as impermissible lease clauses.
What was that number again?
38-12-801. It's going to be the letters in front of it are CRS.
I had another comment about if you want to pay your rent by check, could the property manager, landlord charge extra for a check? Just because you want to write it out as a check?
Instead of going through
cash or direct
Yeah, instead of going
deposit.
through like a portal.
I suppose they could, if there's some kind of administrative fee attached to it.
Well, in a portal, don't they charge you like $2 or $3 extra for that?
Some of them do as
Yeah.
well.
They're charging us 20, if we write out a check, they charge an extra $20.
So it sounds like you may want to apply for services and see if there's any advice you can receive on this matters. Just because as we're getting more and more into the details of your lease here, these just aren't really questions I'm able to answer in a vacuum, and I really don't like taking guesses at things where I don't have an answer for. Yes, ma'am.
So you did mention about the shootings in the dwellings. Now, that's only, they can't break their lease if there's like, I want to use the example, but I can't. We get the question a lot and I just don't know how to answer it. Should I tell them to seek legal advice when it comes to, so the situation that's happening in Denver, we just have them go to legal advice for that type of situation?
Yeah, if it's a general question about what's leaving my neighborhood, get out of my lease, it's really going to be more lease by lease dependent. Sometimes, folks can just reach an agreement. But at that point, maybe kind of the Justice Center's Call a Lawyer Clinic on Wednesday nights a very valuable tool for folks. They're also more than welcome to apply for CLS assistance as well.
Okay.
Yes, ma'am, in the back.
Yes, can I ask a property management company to give me information on whether or not the property I'm at has ever had mold? I sent 2 email messages and neither one was replied to.
There's not a requirement for mold. For folks online, the question was, can I send my landlord an email or request any prior incident reports regarding mold? For mold, no, there's not a rule like that for mold exposure in a property. There are some, for bed bugs, maybe, but not for mold, to my knowledge. Yes, ma'am.
What kind of information would I need to bring with me to apply for legal services?
You can apply online. You just need kind of basic information, any documentation that you want us to be able to kind of include in staffing the case as well.
So if I come in person and have my lease and all,
to be able to take copies of that, scan that to be able to further investigate it and then staff the case with our attorneys.
do you need like any money down? Do you need to?
Not charge, sorry, we do not charge for legal services. We are a nonprofit organization here in Colorado. We do not charge for legal services.
Do you need like driver's license, valid, anything like residential?
Yeah, no driver's license. There are income qualifications, but you don't need to bring in pay stubs.
So that means proof of how much what you're. Oh, so there's no income qualification.
No. There's no verification. There's income restrictions, but there's not verification. Okay. Yes, ma'am.
Can Denver residents contact you, or do you have to?
Yeah, we have offices all over. We have 19 offices across the state.
Okay.
12? Why did I say?
Yeah, well.
Gosh. Yes, absolutely, they can. We are a statewide organization with offices that serve all 64 counties across the state. We have a coordinated statewide intake system where folks can call in from wherever they are in the state to be able to hopefully receive advice that day. Relative to the volume, but absolutely, whether you're in Colorado Springs, you're in Del Norte, you're in Grand Junction, you're in Denver, we are here to assist so long as you qualify. Any other questions? In person, I don't see any more online. I really want to thank everybody for coming out this afternoon. I hope this information has been helpful for you all. Also online, thank you so much. I really enjoy these and something out of them as well. So thank you so much for coming today.